Welcome back to The Legal Alternative with me, Sam Pawson, joined as ever by Nils. Nils, how are you?
I'm good, Sam.
Yeah, good. Not together, I'm afraid, today. Diaries couldn't connect, but no, I'm good. But in the swing of February, very busy. Employment Rights Act, which I'll mention again today. Rugby season in full swing. So no, all good.
Good stuff. Good stuff. Hit me with some Employment Rights Act stuff then.
I'm going first today, and everyone's favourite subject, trade unions. Nils, last week when you couldn't join me, I gave a bit of a update on a number of the imminent Employment Rights Act changes. I intentionally left out trade unions because there's quite a lot to deal with trade unions. And I know it is a bit more of a specialist subject for some of our clients who obviously don't recognise trade unions. So if you don't recognise trade union, feel free to skip to Nils's part of the podcast. But again, just quick updates from me. They are important if you do recognise a trade union. But the background to this, Nils, is this is what I would call more the norm of political changes when you have a change of government between obviously Conservatives and Labour. You generally get trade union issues obviously coming up. And this would be what I would normally see as a common change when there is a change of government. I think what else has happened isn't the norm, which we've talked about, but this is more kind of the norm. Generally, obviously, Labour favouring the trade unions, more the Conservatives not. So back in, if you know, the last Parliament, we had a number of the Trade Union Act, which made a lot of industrial action more difficult. What we've actually seen now is a repealing of that act to do with a change, if I'm being technical, to the Strikes and Minimum Service Levels Act 2023. So what we're seeing is a number of those matters being repealed and changed. We're getting more trade union stuff down the line, but what I'm going to focus on today is actually some changes that came, not very well, but widely reported, that came into effect the 18th of February, where we had some changes. So I'll give a bit of the headline details to those reforms. So we have 5 in total. So we have the industrial action notice period, which has been cut from 14 days to 10 days. So obviously giving companies significantly less time to prepare for industrial action. Your ballot mandate increases the mandate period for 6 to 12 months for any ballots opened after the 18th of February. So that ballot can last a lot longer for trade union action. Dismissal protection, the ERA, the Employment Rights Act, removed the 12-week cap for automatic protection from unfair dismissal, and now applies irrespective of when that industrial action occurs. Notice of industrial action ballot, the ERA now reduces the amount of information that unions must include for industrial action. So you used to have quite a lengthy list of information that had to be provided before industrial action could be taken. That's now significantly reduced. And finally, political funds 10-year ballots. Historically, every 10 years, the union had to ballot their members to talk about the maintenance of political funds. Again, that has been removed. So 5 quite technical updates, as I say, won't apply for a lot of our listeners. Wider political circumstance, this is making industrial action easier, essentially. But so obviously for those who do recognise a union and an industrial dispute, hugely significant impacts. For a lot of our listeners, not so much.
Just for my own interest, that last change, do they not need to ballot at all now?
No, not at all. On the point of political funds, it's you used to have a requirement every 10 years that they had to ballot members about the maintenance of their political funds. That's been removed now.
Okay. Well, I've had limited exposure really to unions, so interesting stuff there.
Yeah, so we're on to your thing, which has a bit of an employment context, Nils, but immigration post-termination, I think you're talking about.
Yeah, so I think we've done a lot on the pod about how to employ someone who doesn't necessarily have the right to work in the UK, and we've done a lot about how you deal with them as an employee once they're in the UK. What about when they're employment needs to be terminated. So just to recap, migrant workers obviously in the headlines a lot at the moment. A migrant worker is someone who doesn't have the right to work in the UK. Conversely, someone needs permission to work in the UK if they're not subject to immigration control at the moment, unless they're exempt from UK immigration control. You need to be a sponsor, which we discuss in some depth. What employers need to be aware of, though, that there is the possibility that if you treat a migrant worker differently, that could give rise to a race discrimination claim. So a lot of what I'm going to talk about is actually within your wheelhouse, really, Sam. So you'd still have to follow the same process if you're dismissing a migrant worker as you would a non-migrant worker. Otherwise, that might give rise to a race discrimination claim. Equally, if you are in the position where a migrant worker's performing poorly, you shouldn't be in the position where you just think, right, well, I'll let that visa lapse.
Yeah.
And use their right, the subsequent lack of right to work in the UK as a reason for terminating their employment. And there's actually been a case on that. Equally, using immigration status to decide someone is redundant or is selected for redundant, again, also likely to be discriminatory. I think what's key, however, is that if you're coming up to a situation where a migrant's visa is about to expire, you've got to actually consider what you're going to do before it expires, because if you let it lapse and continue to employ that person, that's illegal. So always look, as you would with any dismissal, what is the reason for dismissal? So as you'll know, Section 98 Employment Rights Act, are we within that? Because you've got to treat everybody the same. I think what's interesting, though, is the practicalities of when someone's visa is expiring. So should you pay the notice or should it be served? And I think that's why it's key that you get the drafting of the employment contract right. Because if you are in a situation where it's almost come up on you too quick, you're going to have to pay in lieu of notice. So you've got to make sure that you have the right to dismiss in accordance with the contract, but also so that you're not employing someone illegally. Against a dismissal, make sure you offer that to a migrant worker in the same way that you do to someone who isn't subject to immigration control. Equally, when that person's employment is terminated, that isn't the end. Make sure you're notifying the Home Office of that employment ending, because that may be an immigration offence if you don't do that. So there is quite a bit to consider in terms of not only when someone's leave is coming up, but equally during the course of that person's employment with you. Make sure you're keeping up to your record-keeping duties, and crucially, treat that migrant as you would any other employee. So it's not about hoping a visa ends because they're poorly performing, but equally, it's not about treating that person differently if they are a migrant worker. So a very whistle-stop tour there of issues around termination to consider.
Yeah, I think the scenario I always look at generally is I think this is good practice with any fixed term employee, that the expiry of the fixed term, or in this case, the length of the visa, doesn't automatically bring the employment to an end.
Yeah.
So there's a lot, a lot of our clients, coming back to the sporting field, we often use the idea of these long fixed term deals that take someone over 2 years of service. The expiry of that fixed term in itself isn't a fair reason to terminate their employment. It can be, as you said, if we follow the right process, and we can look at SOSR, we can look at redundancy, we can look at other reasons for dismissal. So I think you adopt that same approach for me, Nils, with visas expiring. It's be aware of that. Really, I think really good practical points on payment in lieu of this kind of creeping up on you, and obviously the added kind of practicality reporting it to the Home Office. So lots to see here. As always, for me, let's come back to the Employment Rights Act changes. Visa lengths, we're going to look at 6-month unfair dismissal rights. So a lot of people's length of their visa will be in excess of that. A lot of people's fixed term contracts will be in excess of that. So when we're looking at, just because someone's the deal of you employ for a year, your visa's for a year, you can't have that as you said, this like an automatic end and everyone just shakes hands and moves on.
Yeah.
There is now going to be a definitive process to follow.
Yeah. And let's bear in mind as well, this could apply to someone who isn't subject to immigration control. So if you have an email chain saying X employee who is subject to immigration control has a visa, we're just going to let that visa lapse because they're not a very good employee.
Yeah.
If that becomes known to somebody who's then not requiring a visa to work, they'll say, well, hang on a minute, you just let that person's visa lapse. Why am I now being subject to a poor performance procedure when that person wasn't? So it's about looking at it in the round, isn't it? And it is difficult. It is difficult.
Yeah, absolutely. And as always, because it's difficult, seek advice.
Yeah,
as soon as possible would be our overarching advice.
Absolutely, yeah.
Good stuff. At the office now, both been out and about. We were both our friends and colleagues at Doncaster Rovers last week for what the football purists would have enjoyed, but it was fantastic hospitality and a good result for Donny, not so much for your boys at Huddersfield, but an enjoyable evening. I was at the Rhinos for York last week. Apologies, it's you coughing away. Who are now off to Vegas. So exciting times. We'll hope we have no issues in Vegas for the players that require any assistance, and everyone comes back safe. So no exciting times for us on the sporting front.
It is, and the Las Vegas games is huge, isn't it? I don't know how many fans are travelling. I suspect both Leeds and Hull KR, two of the better supported clubs away from home. We'll take quite a few, but I think we've had a pretty positive start for every club that we act for in Super League, pretty much.
Yeah, Wakefield could do with a win, but apart from that, I think all positive starts. Away from the sporting world, I've got some seminars coming up. We'll just talk about for your team attending our performance management update on Thursday. Lots more events and seminars coming fast. So I was always go on the website, chadwicklawrence.co.uk. I believe /seminars for all your details to sign up. Lots coming up. Flexible working, employment rights updates. So lots coming fast and exciting times ahead.
Absolutely.
Good stuff. Well, that brings us to a close today, Nils. So I love to see you all, and it's goodbye from me.
And from me.
Well,